To the sheer disbelief and perhaps disappointment of a great many people, Ricky Jones was acquitted of the offence of encouraging violent disorder. Now, this has led to many questions, such as, has this now set a legal precedent? Is it now legal to go out and say exactly what he did in the manner that he said it and get away with it because somehow there's a legal precedent against it? Well, the short answer is no, it hasn't set a legal precedent. The longer answer is a little bit more complicated, which I hope you'll stick around for. But there are other questions posed as well, such as, can't this be reviewed? Can't the public sort of appeal somehow to the Attorney General to say this needs to be overturned? Can Keir Starmer overturn this? That's what some people are asking. In fact, I've seen this posed as a bit of an argument to some barristers to say, don't you know case law? This is now a legal precedent and this is now perfectly legal. But with great respect to those that have said those things, that is not how it works. That is not how common law works. And to put it bluntly, jury trials and jury verdicts do not set a legal precedent in this way. That is not to say, however, that they might not be a little bit persuasive, but let's talk about it throughout this video. But first of all, if you do like this legal input, to clarify a few of these questions, please do subscribe to the channel and hit the like button. That really does help my channel grow. I thank you all so much for over 800,000 subscribers. I'm on my way to 1 million subscribers. Thanks to you for watching and subscribing. And just as a complete aside, just to quickly answer a query from a viewer about uploading ID to receive goods from overseas, and how this will interact with digital ID, which the government is rolling out. I dealt with all of those on one of my Black Belt Secrets videos, which I will link below, so please do go and watch that, and you'll get those answers there. And if you want what I really think about this Ricky Jones trial and all of these sort of things, I will do that today on my Off the Record channel. Please pop over there and subscribe. We are now 84,000 subscribers. Let's head to 100. Pop over there and subscribe, and I'll see you there for my personal views on this case. So first of all, the briefest overview of common law, what it is, what it does, and what it's not. Now, you might have also heard of the term of reported cases or cited cases, case law in general. That is where you get a case which is referenced by the court that it was in, the year that it was in, the names of the parties, where it was reported, so like the All England Law Reports or something like that. Law students will be intimately familiar with those, and if you're not, you need to be, so that's probably a good starting point. But these cited cases do cite a legal precedent that courts below the court that made that decision need to follow. And the clue there is in the way that I've explained it, because when the court makes a decision, lower courts must follow it. So let's go right to the bottom. Magistrates' courts' decisions are obviously not binding on anybody else, although they might be persuasive in some way in the way that they applied the law and so on, and that applies the further up the chain you go. Right up to the Supreme Court, you have a Supreme Court decision on a point of law and a point of public interest, which is how the Supreme Court makes its decisions. All of the lower courts must follow those decisions. So to give you an example, the recent Supreme Court ruling in For Women Scotland that the word woman in the Equality Act means biological woman. Any other court now that gets a case on this point of law where they're applying the law to the facts in the case, they must apply the ruling from that Supreme Court judgment. Now that applies to all other things, but obviously in contrast to those, these jury findings are not a decision of the court as such. It is a jury verdict. It's either an acquittal, meaning they are not guilty, or it is a guilty verdict, or indeed it is a non-verdict. So they are a hung jury, they have not reached a decision. That is not then the end of the case for that particular charge. That can be retried by the CPS or even privately. But a jury verdict is either guilty or not guilty. And not guilty is not the same as innocent, but we digress. So in general, where a jury has made a decision, it is not open to challenge. But there are some exceptions. In fact, some people think that if you've been tried for murder and acquitted, and then you can go and admit the offense later on, and you can't be tried because of double jeopardy, and you can't be tried for the same crime twice. Well, that's not true either. In fact, there was one such case like this in the case of William or Billy Dunlop, who was sentenced to life for murder in 2006. He was tried twice for murder, and in both cases, both juries failed to reach a verdict. After which, the CPS decided not to pursue a third retrial, as is customary, because to continually pursue a retrial when the juries are unable to reach a verdict is seen to be oppressive and unfair. The judge then directed an acquittal of Billy Dunlop. However, that then led him to believe that he could go on and brag about his murder because he believed that he couldn't be tried again. However, after years of campaigning by the victim's mother, this led to a change in the law in 2005, overturning 800 years worth of law on the rules of double jeopardy. So having been acquitted in 1991, this then meant that the Court of Appeal was able to quash his acquittal from 1991, and the police reopened the case. Obviously now admitting the new evidence, being his recent confessions to the murder, he then pleaded guilty and was sentenced to life imprisonment in 2006. So this is an example of one of the exceptions to the rules on double jeopardy. Now, generally speaking, there are very few ways that these things can be challenged. For example, in the Criminal Procedure and Investigations Act of 1996, in the case where somebody has been convicted of interfering with the administration of justice by way of intimidation of a juror or a witness, and another person has been acquitted of that offence as a result of the intimidation, then proceedings may be taken again against that acquitted person for the offence for which they were acquitted. Now, obviously, these are extreme circumstances and not likely to come up very often. But there is also, under the Criminal Justice Act of 2003, under this section, somebody may be retried even though they've already been acquitted if they've been acquitted of a qualifying offence. Those are of the more serious nature, which are listed under Schedule 5, Part 1, including murder, manslaughter, rape, etc. And they can only be retried if, under Section 78 of this Act, there's new and compelling evidence. And so if the evidence is compelling, if it is reliable, substantial, and in the context of the outstanding issues, it appears highly probative of the case against the acquitted person. And of course, the evidence is only new if it was not adduced in the proceedings in which the person was acquitted, or in any appeals and so on. So in the most serious cases where there is new and compelling evidence that is reliable, substantial, probative, somebody can be retried for the same offence, but only in narrow and exceptional circumstances. And so in all but the most exceptional cases, somebody will not be retried for the same crime twice. Neither will their acquittal set any precedent for anybody else being charged and tried for the same crime. Even if they were saying exactly the same thing in exactly the same way, it would still go to a jury, and the jury might reach a different decision. And there is no precedent set by the previous acquittal over that jury. The jury is not compelled to follow a previous jury's decision. Save unless, as I said, in the most extreme cases, there are ways of reopening the case with new and compelling evidence. And just to mop up a few other questions as well, I've seen quite a few surprising, to say the least, alarming to go even further, comments to suggest that Keir Starmer or the Attorney General or somebody else should step in and overturn this acquittal. That is, again, not how it works. We have a jury system, the jury reached their verdict, and that is it, save for the few exceptional cases that I've outlined here for overturning an acquittal on new evidence and so on. But none of the MPs and no one else in government has any say in what a jury decides in a case. What I will say, and one criticism that I will make, is that there is a video, if I find it, I'll slot it in, but one criticism that I do have is when the civil unrest unfolded last year, is that Keir Starmer said quite clearly that people would be held on remand until their trial.
Be in no doubt, those that have participated in this violence will face the full force of the law. The police will be making arrests, individuals will be held on remand, charges will follow, and convictions will follow.
Now, I think that was bordering on an interference with the administration of justice, because it is not his decision for the courts to hold somebody on remand. He can't even direct the courts to hold somebody on remand. That should be an independent decision of the judge based on the law and the rules. As I stressed in my video yesterday, I think it was yesterday, I lose track of what day it is, but in my video on this point, there is a presumption in favour of bail of somebody who has not yet been convicted. It's a rebuttable presumption, meaning there can be arguments against it, but the starting point is they should get bail. And so there are arguments about bail for both Lucy Connolly and for Ricky Jones. And it is at least arguable that there was some kind of interference by Keir Starmer putting out this political messaging, which the judges should have ignored, that people will be held on remand. And that is a valid criticism levied at Keir Starmer, who, as a former lawyer and KC, should know better. He should not have made that statement. It should not have any effect on the judiciary whatsoever, and decisions on bail should be entirely independent. And so that is one criticism that I have, and I think people share. And I think that it could well have made a difference. If Lucy Connolly had been given bail, gone home, had time to think about it, it may have changed things. And without seeing all of the papers and all of the arguments, etc., I don't know why she wasn't given bail, but from what I know, I can't really see any substantial grounds for believing that she'll commit further offences, interfere with witnesses, abscond, or any of the other things that would be rebuttable against the presumption in favour of bail. Those are my criticisms. Make of them what you will. Let me know what you think in the comments below. But hopefully I've mopped up all the questions here about Ricky Jones' acquittal in this video. It's not a legal precedent. It doesn't set any case law or anything like that. Save unless the only way in which this would set any legal precedent is if there was any kind of appeal based on procedural irregularity or legal irregularity, and there was a point of law upon which then went to the Court of Appeal, for example. The Court of Appeal ruled on something either with procedure or law, and then for that reason something changed. Those are points upon which that then become case law that lower courts then need to follow. So there's all sorts of bits and pieces, such as if someone was sentenced and they did not receive credit for an early guilty plea. There are questions about how that was indicated at the first instance. Things like this have been to the Court of Appeal. Cases such as DPP and Barrister, where he was filming a collision on his phone, where the law that then led to the change in the law with Regulation 110 of using your mobile phone whilst you're driving. But at that time, it didn't apply to using it for cinematography, for example. So those are very intricate points of law that do become case precedents once decided by, let's say, the Court of Appeal or the High Court or wherever. So either way, I hope that was interesting. Please do subscribe, and I'll see you next time.